the streaming. Okay, no problem. Let's start. Just I would like to test this, and will start this significant question. Well, I say that no one is watching this video. So our discussed matter on point of problems of interpretation in terms of constitution. So let us discuss on point of this. Okay. First of all, Mr. Kobe, you are the candidate. So how can you get a lot of marks to be a civil judge? First of all, you have to focus on point of this question, problems of constitutional interpretation. You have to put here the introduction. Like this, a constitution doesn't interfere itself. Its meaning is shaped through judicial wisdom and social, political, and moral tensions. This is the cut from several, most of the jurists in the world. And constitutional interpretation is a complex judicial practice because a constitution is not an ordinary state. This is not a statute, ordinary statute, like CPC, CRPC, Penal Code, or Evidence Act. It is a supreme, organic, and enduring document, not to write, just it should be kept in your CPU, how to write, and how to actually focus here the landmark decision in the world. Comparatively study from the side of Bangladesh, UK, USA, India, Pakistan. Those countries are interrelated, and the comparative study and comparative writing skill will assist you to get a lot of marks to be a civil judge. So constitutional interpretation is a complex judicial task because a constitution is not an ordinary statute. It is a supreme, organic, and enduring document designed to govern a nation across generations. But the interpreting constitution provisions could face multiple theoretical, practical, and institutional challenges. These challenges are known as the problems of constitutional interpretation. So what are the problems? Only 2 viewers are watching this video. So those are the candidates, especially those are the candidates of BGSC. The 18 BGS. You can cut a good figure if you buy those handouts which are made from the hand of ours, that the law doctor, the best law academy in the world. So now is the meaning of problem of constitutional interpretation. What is the meaning? Problems of constitutional interpretation refers to the difficulties, conflicts, and uncertainties faced by the courts by determining the meaning, scope, and application of constitutional provision in challenging social, political, and economic context. There's a 3 number. Number 1 is social. Number 2 is political. And number 3 is economic context. That should be kept in your CPU. Not to memorize, and not just if you are able to speak in such a way, then you can get a lot of marks. No doubt, Mr. Kavi. And you are the students of contact base, so you can be easily a civil judge. No doubt in this regard. Now, the nature of constitutional interpretation problems. What are the natures, and which is the nature in this respect? And what are the problems which will be faced by the jurists or the judges or the justices in the world, not in Bangladesh. That is totally on point of the UK, USA, Australia, Canada, Pakistan, and our neighboring country, India, Myanmar. So how to practice that? These problems arises because constitutional language is broad and general, and constitution is intended to be permanent. Social values continuously evolve. Political power struggles influence interpretation, and balance between the organs of state must be maintained. But our situation at present, like this, the doctrine of necessity, they can focus on point of the referendum, like this yes or no, in terms of Ganaphat. So what exactly hustle and bustle in this matter that the difficulties arise in our country? No doubt in this regard. So major problems of constitutional interpretation, just imagine that those were the candidates, just how to write in taking these several headlines and in what exactly mentioning several judgments in tracking this fact of the case and what is the issue may arise in that very case, and decision-making power. Not only that, the reasoning system, why this coach decide in taking this judgment. And the major problems of constitutional interpretation, number one is ambiguity of constitutional. What exactly the thematic approach ambiguity of constitutional language. Our constitution is made from the what exactly the intellectual, so-called intellectual, but at all there is no test what exactly the testing movement to prove that. So the ambiguity of constitutional language, what exactly the problem of vagueness, that the ambiguity that is not transparent and lucidity. Constitutional provisions often use abstract and open-ended expression such as liberty, equality, reasonable restriction, public interest, and due process. Of course, due process is being practiced in USA, but procedure established by law is being practiced in India, and we actually in Bangladesh in accordance with law. And the restriction may be focused here. So this is factually written constitution. But there is an option to actually make lucid it that the constitution which will be prevalent in terms of referendum, yes or no. So coming examination just go through this systematic way. And problem why? This just terms lack precise definition and invite multiple interpretation. So there is a problem to interpret that the constitutional law. And this made us several mandates may be offered. Here the 3 times referendum will be happened in our country in the regime of Ziaur Rahman Irshad, what exactly Hussain Muhammad Irshad, Ziaur Rahman, and in terms of what exactly the I don't know that's in terms of what exactly the era of Khaleda Zia. So the judicial response courts adopts a liberal, purposive, and contextual interpretation. So what is the case law in this regard that in point of the ambiguity? The case law judicial balance, there is the case law state of Madras versus VG Raw, All India Report of 1952 and Supreme Court maybe 196, the page number. It is very much difficult for me to recall that. So principal reasonableness must be judged objectively by courts. But this reasonableness must not, of course, must be judged, must be interpreted objectively by courts, but subjectively that is practicing in the whole world. And rigidity versus flexibility, problems for permanence, explanation, a constitution must remain stable yet adaptable. And problem why is the excessive rigidity causes stagnation, and excessive flexibility risks judicial lawmaking. And judicial balance living constitution doctrine, case law, SP Gupta versus Union of India, All India Report 1982, Supreme Court 49. So in this principle, constitution must adapt to challenge what exactly the changing needs. What is the changing needs in our country? Whether this is a yes or no. And conflict between fundamental rights, whether the problem of international conflict and explanation to different fundamental rights may be come into conflict, like 26 to 47 articles in in our constitution, that the draft constitution in our country. The shaping movement to the language is crystal clear, and this is the what exactly the integrity is being practiced in the language of laws, but practically that the boot will come to force to fresh you. So problem is what should prevail? Judicial to a harmonious construction case law, and this is the case law, and the Lebanon state of Moishu, and this case law fundamental rights versus directive principle may be problem. So what are the directive principle? Non-justiciable fundamental right governance in this the article 8 to 25 maybe. So those article prescribe in terms of fundamental principle of state policy. So there is what exactly the thematic approach? There is a conflict between the two, like the directive principle and the fundamental rights. So this is the problem to interpret that. And judicial approach, harmonious and propositive interpretation. So in this case law, there's the judicial activism versus judicial restraint. There is a fucking land, the loophole, and that's why. And Asma Jilani case in this regard, prescribed in this matter. And original intent versus present meaning. So those are the problems, and several problems may be focused here. Now the correction, the table management system in this regard. Now the first one is the problem of constitutional interpretation and the case laws. So this is very much important and very much significant to get a lot of marks on your kata. Yes, just imagine that. The vagueness, number one is vagueness of constitutional language. There is no word which is lucid and transparent, and that's why the meaning of reasonable restriction on due process disrupted. There's the disputed whether in accordance with law, in restriction, several restriction or is procedure established by law. So those are what exactly the disputed matter in terms of vagueness of constitutional language. In this matter, the state of Madras versus BG Roa, this case indicates that the All Indian Report 1952 and Supreme Court 196, and I have already focused on this matter. And rigidity versus flexibility. So what is rigidity versus flexibility? Constitution should adapt to social change. Now this change in Bangladesh, the 5 August, the social change, political change, economic change. Oh my God. So the rigidity versus flexibility is the whether the constitution should adopt a social change. SP Gupta versus Union of India, All Indian Report of 1982 and Supreme Court 149. This case prescribed in this matter, and conflict between fundamental rights and religious freedom versus social reform. There is a problem to interpret the constitutional or the constitution in every country which tax like the written constitution except UK. And fundamental rights versus directive principle, provided rights versus socio-economic justice. In this matter, there's the landmark decision, Minerva Mills versus Union of India, or Indian Report of 1980, that the Supreme Court in 1789. So in this matter, there is a problem. So how to write? And judicial activism, so there is the active role of judges or justices. The jurisprudential knowledge, jurisprudence prescribes that the judges are not allowed to make the law. They just declare the law. Oh my God. And there is no judicial activism in our country, especially, and that's why this is the restraint may occur in our country, and courts accused of overstepping, this is the legislative domain. And Asma Jilani versus Government of Punjab, PLD 1972 and Supreme Court 139 indicates and shows you the crystal clear way. And original intent versus what is the original intent exactly which will be practiced here, and present meaning of that language which will be used in the constitution. So there is a referendum whether yes or no, it depends on you. And framer's intent versus moral interpretation is totally lag behind. There is a distinction between the two, that the framer's intent, who actually framed this constitution, and the moral interpretation like Sarsis, Nahid, and whatever maybe that what exactly the Jara, they are practicing in talking this, whether this referendum, whether in the yes or no, it depends on you. Whether amendment, framer's intent is not crystal clear. Those who are the, those who are the professor of laws, or the doctor of law, or the students of law, and associates of law, and advocate. Those are the advocate, barrister, judges, justices in our country and in the whole world. So the Keshavananda Bharati versus State of Kerala, All Indian Report 1973, Supreme Court, 1461 piece prescribed in this matter, whether this is the original intent and present meaning. Limits of number, another number is limits of amendment power, whether amendment can destroy constitution. In this matter, Mr. Kovic, just imagine, not to memorize and not to write on your card. Just imagine that you can easily be a civil judge, no doubt in this regard, inshallah. Limits of amendment power, whether amendment can destroy constitution. And Anwar Hossain Choudhury versus Bangladesh, 41 DLR Appellate Division 165. This is the case law on the landmark decision on point of this limits of amendment power. This is totally known to you. That's the 8th Amendment case law. There's a decentralization of the what exists the permanent bans of High Court division and it's Article 100. You know. And federal balance center in crossing the state of Bombay case law prescribing the separation of powers, executive interference in judiciary. So separation of power is totally, yes, this is lucid, but totally the independence of judiciary is not being practiced in a country. Those were the executive of God, you know, the legislature and executive, the bosses, all the leaders in a country, they practice the power, the arbitrary power, not to ensure that's yes, this is separation of power under Article 22 of the Constitution, but that is practically that is not independent. So there is no hope for the future that the independence of judiciary. So this is sham for the whole nation, and the bank loot and the coyote robbery and that hegemony is being practiced in the whole world and in our country. So the separation of executive interference in judiciary, this is so much acute in this matter. If you have ability to recall that the Mazhar Hossain versus Minister of Finance in Bangladesh case law 52 DLR Appellate Division added to this is the glaring example. And expansion of fundamental rights and water life expanded beyond mere existence. And the Munufai Disha versus LIC, this is the case law, and this is had from the Indian case law. And political sensitivity. This is political sensitivity. You know, there's a course deciding politically charged disputes. Federation of Pakistan versus Maulvi Tomijuddin Khan PLD 1954 FC 240. This is the phase number, this is the glaring witness to prove that situational case. In this matter, the political sensitivity is being practiced in our country. And last but not least, the constitutional supremacy. Yes, that the language which is very much norms and what is the ethics and the religion. Not only that, the norms, ethics is being practiced in normalizing system. Normalized system is being practiced. The language is soft. It's a lucid soft, but the vagueness is being practiced here. Constitutional supremacy, yes, this is lucid term. This is a gentle term, but this term is not being practiced in our country. What exactly the boot showing that's the life and the liberty of a human being has been hazarded in nature. And that's the ordinary law conflicting with constitution. Several laws, which are ordinary law for like this, for example, CRPC, you know, there is an option of review system. But the practice movement under Article 105, this is being practiced. But there's ordinary law conflicting with constitution. Several ordinary laws conflicting with constitution. And in this matter, there is a landmark decision, the firstly evolved case law in the world, that's Marbury versus Medicine, 1803, 5 US and 137 pages, maybe. So in this case law, this is the case law in terms of the judicial review. So the conclusion remarks today, the concluding remarks. So what is the conclusion or the concluding observation of mine to you exactly? How to write on your kata? Those are the candidates of BCSC, and no one is watching this video. Those were the. And this is what experiment links. Dear sir, yes, you are the read-on text from the side of written below link in terms of yes dear. So the concluding observation in this regard, in my opinion, the constitutional interpretation is a journey between continuity and change, guided by the reason, restraint, and responsibility. In my opinion, again, please. Constitutional interpretation is a journey between continuity and change, guided by reason, restraint, and responsibility. Problems of constitutional interpretation are inevitable in a living constitutional system through doctrines such as harmonious construction, basic structure principle, living constitution, and proposed interpretation. Courts address these challenges while in preserving constitutional supremacy. Judicial wisdom lies not in avoiding these problems, but in resolving them with a balanced discipline and constitutional fidelity. So, today's number. Bye-bye. Bye-bye. Bye-bye.